Have you been issued an administrative complaint or a notice of intent to deny or some other notice? Let's talk about your rights you have in this process. It is important to note that under Chapter 120 of the Florida statutes, you have the right to an administrative legal proceeding, which is referred to as the Administrative Procedures Act. When you do receive an administrative complaint or notice, it's important to remember that filing an election of rights response would be one of your top priorities within the allotted 21-day window. If you do not file within this 21 days, there is no extension, and this is a very hard cutoff. But you may be wondering, what happens if I don't file in time? Well, in Florida, you may not have any other recourse. Additionally, if the election of rights does not meet the legal requirements, the state may issue what's called a default, and you will lose your ability to assert any of your rights under the Florida law. When completing your election of rights form, you must choose either for an informal hearing or a formal hearing. When choosing, it is helpful to have a skilled attorney in making this decision. Do not, and I repeat, do not rely upon representations told to you that someone who works for one of the state agencies. For this process, we highly suggest contacting an experienced attorney as your case is moving towards a hearing, which is similar to a trial. After we help you finish your informal or formal decision before the Division of Administrative Hearings, the state will issue what's called a final order, which may deny an application or revoke your license. However, after the issuance of the final order, you only have 30 days to notify the state of an appeal of that decision. If you miss that 30 days, you lose your right to appeal that decision. With this notice of appeal, you can either seek what's called a stay order granted by an appellate court, which may allow you to continue practicing during that time period. But many times when you receive a complaint, the state may provide you with a voluntary relinquishment of your license. In many cases, this may seem like the easy way out. However, many clients that we have represented did not understand that a voluntary relinquishment is permanent. It is considered discipline, and it may prevent you from getting a license in another profession or even in another state. The medical legal system here in the state of Florida is a tricky one. Do not take it for granted or think that you can do this alone at the risk of losing your license. Our team of professionals here at Howell Buchan & Strong are very experienced in this area, and our goal is to help you keep the license that you've worked very hard for. If you have any questions regarding your unique situation, please give us a call for one of our free, no obligation consultations. Our main office is located in the capital city of Tallahassee. The number is 850-877-7776. We have local offices located throughout the state, and we will be here to answer any questions you have regarding your case or filing process.